Alex here with the legal nuts and bolts video on non-compete agreements. These are something that are pretty common when you go out and get a job. Not all industries have these, but a lot of them do. You sit down, you get hired, and they have you sign a piece of paper that says you are not allowed to compete against that company. If you leave, whether you're quit or whether you are terminated, I don't believe matters. I think in both situations, you are effectively blocked from working for a competitor. Um, I can't really give 100% accurate answers as to how this, what I'm about to say is how these are thrown out in court. They are sensitive to being deemed unconscionable. They are sensitive to being deemed contrary to public policy, anti-competitive, and all that stuff. But the way that it happens isn't really consistent with all 50 states, and it's not something that just remains constant. It's kind of been ebbing and flowing. So of course, like with all the other things that I come up with all the other topics that I come up with in my videos, make sure you go out there and do your own research, especially since you're going to know the specific facts of your case, and you're going to be able to also look at the specific statutes and precedent in your state. There's probably a little bit of federal authority on this as well. I'm pretty sure that the Supreme Court of the United States has rendered some opinions on this sort of mechanism to keep workers from going and competing against their employers. The first thing, well, I wanted to point out three main things for people to look at, because even though I can't give a specific answer, I can at least give people an idea as to what to go and look into. The first thing I wanted to say is it's my understanding this only applies to going out and creating your own business to compete with an employer. It's my understanding that this does not that these contracts do not allow an employer to prohibit an employee from leaving and working for a competitor. If anyone here has any insight on that at all, because all of the research that I've done points in that direction, and honestly, it doesn't seem to me like there's a whole lot of exploitation to that effect out there. It doesn't seem to me like people are signing agreements promising to not work for a competitor. But again, correct me if I'm wrong, post it in the comments below. If anyone ever has been asked to sign some kind of non-compete saying that you're not even allowed to work for a competitor, definitely post it in the comments below. I know that there have been employers that have been sued just for even promising not to hire each other's workers. That was a big one that I think started with Steve Jobs. Before he died, there was a massive lawsuit against Apple, and then a whole bunch of other companies that sort of jumped in on it that promised to not hire each other's workers. They didn't even have them sign a non-compete. They just sort of secretly agreed not to hire each other's workers, and that alone triggered a massive lawsuit. So anyway, if anyone here has been asked to sign a non-compete that just blatantly says you're not even allowed to work for a competitor, definitely post that in the comments below, because I'd be interested in taking a look at that. Also, if anyone finds any case law on it, I'm curious to see it. I really don't think it's going to be as important as issues 2 and 3 that I'm about to bring up, because I think these are going to be a lot more relevant. Issue 2 is the range of the non-compete. From what I've read, the non-compete is only enforceable up to a certain range, and that range is the sort of area where the employer is doing business. I've heard of a lot of employers trying to say that they do business all over the world now because they're all online and stuff. I don't think judges are buying that, but if somebody sort of finds any precedent or any case law on that, please post in the comments below, because I'd be curious about it. Aside from that, a non-compete may say that you can't create a business and compete with this employer, but from what I've seen, there is authority out there saying that that's only enforceable up to a certain range. And that makes sense too, because if you're sort of operating, if you leave and create a business in a market where the employer isn't even operating, that kind of defeats the whole purpose of the non-compete, because you're not even competing with them. They're not there. So that makes a whole lot of sense, actually. The third is duration. What I mean by that is, the non-competes are only enforceable up to a certain amount of time. From what I've read, it's a year, but I may be wrong. Again, please check your own states. Definitely look into even the federal case law to see if there's any hints as to how long these non-competes are enforceable. But my understanding is after a certain amount of time, it gets to the point where it's anti-competitive. It gets to the point where it goes too far. It makes so that the the employer effectively is able to lock all these people out of ever competing against it. And the United States is big on competition, at least on paper. I don't know, behind closed doors and backroom deals and lobbyists and all that, it's a very different story. But on paper, it's supposed to be a thing that somebody can say, I don't like working for you anymore. I'm going to leave and create my own business and compete with you and take some of your market share. That's supposed to be a thing. It's supposed to encourage um, that both companies, both the former one that had the employee before and now the new one that the employee created, are providing, better services and better products to, the people. And also, it also encourages them to sort of ramp up hiring standards, wages, salaries, benefits, and stuff like that. The more competition there is, the more of an urge to sort of keep ahead of the competitor in all those different areas. So if you're letting employers just lock everyone out of the workforce like that, that's just one less thing that they have to compete against, and that's just then you end up heading into cartelization and all that. Of course, there's all kinds of other factors that go into this, but from what I've read, that's where the whole premise behind making it so that these agreements are only enforceable up to a certain amount of time came from. So the last thing that I wanted to mention, I'm going to mention two more things. The second to last thing that I wanted to mention is that I've read a little bit of stuff out there about Congress putting together some kind of uniform act on how these non-competes are going to sort of be standardized across all 50 states so that there's less chaos. I don't know what stage this is at. I don't know. For all I know, it's already been passed. I don't even know if it's a serious thing. But that does kind of underline that Congress has seen this as an issue that's sort of upsetting people. I know that it's one of the biggest things that comes up in IT, in software development. These non-competes are pretty pervasive. And of course, with the thing that I met with the whole Steve Jobs, Apple shenanigan, I mean, this thing is on Congress's radar. I just don't know if it's actually going to be a thing. If anyone here knows anything about the Uniform Act that's supposed to be dealing with non-competes, feel free to post a link in the comments below, help some of the viewers out with it. If that passes, of course, it's going to change everything because it's going to trigger changes in all 50 states and hopefully make things standardized and a lot less confusing. It's nice that they do that because it's nice that there's all these legal principles out there to protect the public, but most of the public doesn't have any idea that there's any of these things out here. So these illegal agreements, these unenforceable agreements, even though you can't enforce them in court, they end up having this sort of like psychological, I don't want to say warfare, but it's like it psychs people out into thinking that it might be enforceable, and so that they're not going to take any risks and just play it safe. And so, I mean, even though it's an unenforceable contract, it will still make a lot of people comply with it because they'll think it is enforceable. I've also heard of these weird, I don't know why I'm saying weird, I guess it makes sense, but I've heard of this practice, disturbing practice is what I'm going to say instead, of some employers starting to ask new hires if they've signed non-competes. These are just rumors. I hope they're not true. Because, as I mentioned earlier, a non-compete isn't supposed to prohibit you from working for a competitor. It's only supposed to prohibit you from creating a new business. If anyone here has been asked by an employer who's about to hire them if they sign some kind of non-compete indicating they can't work there, please post that in the comments below, because how is that any different from what Steve Jobs and Apple and all those other companies were doing? Blocking employees from moving from one job to another isn't supposed to be legal in this country. It's hopefully what I'm being told is just a bunch of rumors and it's not true, because that doesn't sound right and that doesn't sound good either. So the last thing that I was going to talk about was that there are things I'm not really talking about in this video that are still illegal that I may or may not look into. I just want to give one example that has come up to me in the past. Somebody talked about going to work for an employer, like a salesman position, getting a client's list, quitting the job, and then just stealing the client's list, going to work for another employer, and then giving them the list or using the list over there. This doesn't have anything to do with non-competes. This is illegal for other reasons outside of the boundaries of this video. I did want to bring that up because I've gotten that question a few times in my inbox. So at this point, I'm going to go ahead and end this video. I hope it helps people. I know that I really can't give clear and concise answers as to when their non-compete is going to be enforceable and when it isn't. But at the very least, people know it's possible now that it can be thrown out, and at least people have two really good things to look into, which is the first one is the duration of the non-compete, and the second one is the region as to where it applies. And of course, if you want to look at the other thing as to whether or not they apply to, being able to work for a competitor, you can say that's number 3. Please definitely bring that up, guys, if you've signed something saying you're not even allowed to work for a competitor. I guess with that, I'm going to go ahead and end this video, and I will definitely see you guys next time.